We are going to be speaking about intellectual property as it pertains to speakers. And nobody kind of speaks about this because we don't know enough about it, and we're too scared because if we do mention stuff, it's just going to highlight our own guilt about how much we steal and copy, and we don't protect our stuff. So it's like one of those forbidden subjects that we've kind of avoided for far too long. And now we have found someone who's actually able to bridge the gap between legal and English. And quite hard to find in the legal fraternal, but Roy has joined us tonight. I've heard Roy speak on a number of occasions. In fact, just 2 weeks ago, he addressed us at the Cape Chamber of Commerce on intellectual property. So let me introduce you to Roy. Roy is an admitted attorney. I think that's a good thing. And a patent attorney. He's got over 15 years of experience, which means he's done his 10,000 hours of that. But not only that, because not only does he have an LLB, which is the legal thing there, Roy has a BSc in chemistry and cellular biology. Who knew? Who knew you could spend so long at school? And he's also a CDR, accredited mediator. And so there's a whole bunch of qualifications with that. And even with all those qualifications, Roy has the gift of being able to speak to humans in English, which is a rare thing, like I said, with lawyers with that. And Roy has spoken at a number of places. I've seen him speak on a number of things. Roy is our go-to attorney for our clients as well for all things IP and contractual stuff. So I've been interacting with him for a number of years. So the format of this evening is we're going to hand over to Roy now, and he's going to give us about a 30-minute presentation. And don't worry too much about trying to take everything down off his slides. You won't be able to. We will make this stuff available at a later stage if you need it. And then we're going to follow that by about half an hour of Q&A. So I think rather take time to write down questions, be specific. And then when Roy's finished, Ian will be handing the Q&A sessions, and we'll do that either live or in the question chat box that you can do with that. So I think without taking up too much time and without wasting everybody's thing, I think we've got enough people. We've got 24 people, Roy. I'm going to hand over to you, and I'm going to unmute you. And there we go. Roy, so you just need to share your screen now, and you're A for away.
Well, thanks, everyone. Let me just introduce myself quickly, and thank you very much for the introduction, Bruce. Goodness me, I just loved speaking when Bruce introduces me. Wow. The only anxiety I have is not in presenting the subject matter and presenting all things intellectual property. It's Zoom itself. So I've had a number of, little introductory courses on Zoom because I broke into a meeting which I wasn't supposed to already. So highly anxious with the Zoom thing, but all fair and well. I'm going to share a slideshow with you now. Bruce, can you see that?
Okay, you've shared the wrong slide. Just unshare that and share the slideshow, not the PowerPoint. Sorry.
So that is stop share.
Stop share and then just reshare the slideshow. Yeah.
Is that what you can see there? Great. All right. So the first thing, professional speaking for IP. Now, as a way of introduction, there is certain, let me see if I'm going to get to the next slide. Oh dear. How's that going, Bruce? Resume slideshow. Okay, that's where I'm supposed to be. Okay, so intellectual property. The aspect of intellectual property that is relevant to, I suppose, the audience that we're involved here is copyright, right down at the bottom there, highlighted in blue. But intellectual property is a lot broader than just copyright, and the types of intellectual property: patent, trademark, design, and the all-important copyright. And very quickly, just to give you an overview and to give you context, patents are to inventions as trademarks are to brands, as design is to industrial design as opposed to graphic design, and copyright. And I think for the purposes of this presentation, we're going to focus on copyright because the other three aspects are not relevant. But to know that once you have an intellectual property right in patent, trademark, design, or copyright, you have an intangible asset, a piece of property that you can sell, license, much like you can sell and rent a home. So unlike the other three categories, copyright is a bit of an outlier. Copyright doesn't require an application registration process. In the case of patents, trademarks, and designs, you need to apply to the relevant office, state office, under the auspices of the CIPC for a particular right to a patent, trademark, or design. With copyright, it is not necessary. You do not need to apply. It accrues to you automatically. Well, what accrues to you automatically? The copyright accrues to you automatically the moment that you conceive of and fix a bit of work of creative merit. So the most important term here is fixed, a fixed expression of work of original creative merit. Fixed and originality are of utmost importance when we're talking about copyright. Fixed means it must have some sort of reduction into writing recorded digitally, in analog, embodied in digital data signals. Original, it must come from you, and it must not be derived in whole or in part from another source. So originality is analogous to novelty with patents, but originality means that it originated from you, and you can conceivably originate a work that someone else has originated in another part of the planet almost concurrently, and both of you can independently claim copyright in that work as long as the one didn't get from the other that work or a derivative of that work. And this is a very, very important thing to grasp. Copyright doesn't protect ideas, doesn't protect your thoughts, doesn't protect your concepts, doesn't protect the wonderful creative things that go on in your mind at all times of the day. Copyright protects a fixed expression of that. So an idea is not the subject of copyright. A fixed expression of that idea most certainly is. So when I spoke about in the previous slide about works can come in a number of different types of work. Literary, and I put that at the top because this is the most important and relevant to the audience. Literary works, which includes novels, poems, stories, essays, letters, reports, lectures, and speeches. Musical, artistic works, films, broadcasts, sound recordings, published editions, and computer programs. So it's a real motley crew. And the Copyright Act has kind of evolved and been amended to add rather randomly various types of work. So as technology has advanced, so the categories of work and the definition of those works has been amended and added to. So broadcast, sound recordings, published and computer programs have been added subsequent to the incorporation of the Copyright Act, but it originally included literary, musical, and artistic works. And importantly, well, who owns it? Who owns copyright? So it's a fixed expression, and of course the author is the first person to own copyright. So it has to be, ownership has to vest in someone. And then once it's vested in someone, it is capable of being transferred to another person and so on and so forth. So the first owner would be the author. It's the author who creates the work. And there are exceptions to that. For example, in an employer-employee relationship where an employee is working for an employer and embodied, codified in his employment contract is an assignment, where as soon as the work is created by the employee, it is automatically assigned to the employer. And another exemption is a commissioning relationship where you commission an artist or commission a photographer to make a particular drawing or take a particular photograph. Then the copyright in the photograph or the drawing vests in the person commissioning. But other than that, it is the author. And there is often a conflict as to who the author is, especially when there are a number of people involved in the authorship. And an example of that, it would be in the context of the production of a film, where you have a producer and a director. A producer making the fundamental kind of administrative arrangements for the making of the film, whereas the director is the creative driver of the filmmaking. And it is not a hard and fast rule, but the courts will go for the tried and tested dominant organizer method in the absence of an agreement that would highlight and give ownership to a particular party. In the absence of that, it would be the dominant author, and in this particular example, it would be the producer more often than not versus the director. And as I've already said, once ownership vests in a person, in the author, it's original, it's fixed, it can be transferred by agreement or by assignment or operation, by agreement as an assignment or operation of law. So statutes often create automatic assignments from one to another, but more often than not, ownership is transferred by agreement. And lastly, with the ownership of copyright, even if you were to assign and transfer the ownership, you are the author, you assign your copyright in your work of artistic merit to another person, what remains behind is your moral rights, and your moral rights are kind of a residual right to claim the ownership, the authorship. I am the artist in that particular picture, even though I have assigned my copyright. And I have the right then to object to the distortion of my work. Those moral rights are residual and remain with the author. And just to make it clear, when I talk about, as an example, a picture and an artist making a picture, painting a picture, the ownership in the picture as the physical thing can be bought from a showroom by a person, but the ownership in the copyright as distinct from the ownership in the picture may not necessarily change. So very, very often, the author or the artist who paints the picture sells the picture, but that doesn't necessarily mean by implication that copyright in the picture also is transferred with the physical picture itself. So that must be clear from the sale agreement. When you have copyright, well, what does it give you? It gives you the exclusive right. In other words, conversely, it allows you to stop others from doing the following. And the most important, because copyright gives you the copying issue here, reproduction or copying. That is an act that is exclusively reserved for the owner of copyright. Alongside that, publishing, performing, adapting, broadcasting, or transmitting. So those acts are exclusive rights that are reserved for the copyright owner. And as the copyright is transferred, so the right to reproduce, publish, perform, adapt, broadcast, and transmit are also transferred, with the moral rights remaining residual with the original author. And the term, like with all intellectual property rights, it has a beginning and it has an end. It doesn't endure ad infinitum. And in this case, with copyright, it is typically the life of the author plus 50 years. In some cases, it's 50 years, but for the works that we're dealing with in literary, artistic, and musical merit, it is the life of the author and 50 years. There are exemptions, and these exemptions are, if they are done, they are not considered to be copyright infringements. So the exemptions or a defense to copyright infringement would be if you are dealing fairly with the copyright subject matter. And fair dealing typically includes instances where a person would use copyright in research, study, and personal use, in teaching. And in both those examples, as long as the source and the name of the author are referenced in that particular teaching, research, or use. And as an aside, copyright in political and courtroom speeches, and there are often some amazing speeches coming out of courtrooms, but not so amazing speeches coming out of politicians, but nonetheless, neither of which accrue copyright. So that is an exemption. And those speeches in that context do not accrue copyright. Another exemption is if a lecture or an address was reproduced to inform the public. In other words, it's newsworthy. That publication in the form of broadcast or in the publication in a newspaper on the lecture or address would be an exemption from copyright infringement. So there's a finite number of exemptions, and they are rather complicated. I've really summarized them here, and I'm sure that we can discuss them later. There are a finite number of exemptions. And that gives you kind of a very quick context of intellectual property, 4 categories, copyright being the most relevant, what constitutes copyright, and what constitutes copyright infringement, what rights you have. I would like to give you a kind of a few fun examples of copyright and its day-to-day effect, so as not to get too dry and too caught up in the legalities. So I've got 3 examples, and I think from here we can actually start to discuss the implications of copyright, how it affects you, how it could affect you, with these 3 examples. So let me just move this. Yeah. So in this first example, a lecture scenario, we have a person 1, who is about to deliver a speech, but merely just speaking from memory, he writes down his speech. From that moment, he has codified, he has reduced his speech to writing. He now has copyright in the speech. And that speech is, by definition, a literary work. It's of literary merit. It's using words. It's certainly originated from person 1. It's original. So it meets the originality test. It's not borrowed from another source. And it is reduced to material form. So person 1 has copyright in the text of his speech. And one of the exclusive rights, as indicated in one of the previous slides, is one of the exclusive rights he has is the right to perform the speech in public. So he is invited to speak about this topic, and he delivers his speech to a public audience, which he's entitled to do. That's an exclusively reserved right. However, in the audience, there is another person 2, who, without permission, video records the performance. The question here is there an infringement of person 1's copyright? Another question that's elicited from this is does person 2 own copyright in the film that he has recorded? Bearing in mind that one of the works of copyright, artistic, literary, musical, and cinema films. So a film can be a work of art. A work subject to copyright. So it is conceivable that person 2 may have created something of independent copyrightable material in the video. So that's a question. I'm not saying he does, but it's a question. And then the next scenario is that that person then either gives or sells, not too important, his recording to person number 3 to broadcast or transmit for whatever reason. Here again, is the broadcast or transmission by person 3 infringement? And what does that scenario change if person 3 is a public broadcast, a public broadcaster, and the speech is newsworthy? So perhaps we can open it up to the scenario to the audience. So just if you're looking at step number 3, person number 2, he has videoed the giving of the speech, and he did not have permission, he did not have license. The author, person number 1, did not give him any permission to do that, and therefore it is most certainly an infringement of his right in copyright to his speech. And person number 2 has infringed by videoing person number 1's copyright in his speech. A lot harder, though, is whether, notwithstanding that person number 2 has infringed, he could conceivably have created his own work of artistic merit in his video recording. Does he have, in fact, got independent copyright? It's no defense to infringement, but has he created another piece of work of artistic, worthy of copyright? And the answer there is absolutely not. And the reason why not is because there's no originality in his video recording. He has simply focused his camera on the person giving the speech and recorded the audio of the speech giver. So originality is absent. He hasn't introduced his own creative nuance to the video, which if he did, possibly there would be independent copyright, but he hadn't, and he hasn't. So most certainly no independent copyright. There is infringement. And going on to point number 4, if person number 3, after receiving the video recording, then broadcasts and transmits, is that in fact infringement? In other words, can person number 1 take issue with person number 3 alongside person number 2 for broadcasting? And the simple answer there is most certainly, because broadcasting is an exclusive right of the copyright owner. Alongside copying, alongside adapting, to be able to broadcast your work, to be able to transmit your work to a public audience is a right reserved for the copyright owner. That has been taken away without permission and been done by person number 3. So there is certainly infringement with person number 3 as well as person number 2. And one of the exemptions that I mentioned about it being newsworthy, that a broadcaster can fall into an exemption if in fact the broadcast is newsworthy. In this particular case, the broadcaster would have to have broadcast live from the audience, from the auditorium or the place where the person was giving his speech, because that is set out in the exemption. They're very, very detailed exemptions. They're not broad, open-ended exemptions. So even though he may argue that the speech is of newsworthy content, the manner in which it was done by receiving a video from a third or intervening party would make that exemption null and void, and he would not be able to rely upon that defense. So I've answered the questions there, and I suppose what we can do is go on to example number 2, and maybe
Roy,
just open it up.
before you do go to example number 2, I have some
Yeah.
specific questions around example number 1
Okay, sure.
that have come through the chat. So the first question is, if that speech of person number 1 delivered is not ever in writing, does that make any difference?
It makes absolute difference. There's no copyright. So remember, going right back to the beginning, what do you have to do? What are the requirements? What are the 2 criteria for copyright to accrue to the author? It has to be reduced into some form of physicality or data. So there must be some sort of fixation, and there must be originality. So it's the fixation leg that's missing. So if he doesn't write it down, then goes into the lecture auditorium and gives the speech, and someone records it, that recordal without originality actually is a fixation, and he can claim ownership in the recordal, in the video recording, even if it's not done by himself. So he can go into the video, into the auditorium. He can commission someone to take a video recording of him giving the speech. Copyright vests in that, as if he wrote it down. So it doesn't just have to be written down. It can be video recorded and audio recorded. If a third person did it, like in this scenario, without his permission, he can claim ownership in that video recording. There's no originality in the person doing the video, and it would then accrue to him. He could demand it.
Oh, brilliant. So I've got 2 follow-on questions to that then, Roy. The first one comes from me, which is PowerPoint slides, would they constitute that writing down?
Yes, absolutely. Again,
what if you don't include all of the words? You know, for example, you've got your slide up here, but you're saying a lot of things around those points.
Yeah, so copyright is reserved to the written content. So someone takes my PowerPoint presentations without permission, okay, and we'll get to that, because that's a different issue. The author, in the way that he presents his copyright work, is he opening up for public use? In other words, is he giving into the public domain his copyright work for people to use as they please, or is he reserving his rights to the content? Those slides, that's the source of the copyright. My words, if not recorded, and it goes into space, not the subject of copyright unless recorded.
Interesting. Lois has got a follow-up question. It was Lois that asked the first question about it being in writing, and that is, how will the audience know if the speech is written anywhere or not?
Well, it's not for them to know or not. So the ignorance is no defense. If it is in fact written down, that's it. Bearing in mind that the onus of proving copyright will vest in the author, and if the author can show, look, I wrote it down, then I presented it. Someone then, without my permission, and I made it clear, because that's important, I made it clear that I reserve my rights, and someone copied, adapted, that is a copyright infringement. In the scenario that's of the question, how is it that could anyone have? How would a person know? Well, that's the point. That there is copyright in the speech, but if that person, the deliverer, the author, didn't make known the the alarm's going off. Didn't make known that he reserves his rights, then what would happen is that the person taking the video recording would be allowed to use it, because that would be the understanding. I didn't know, and I didn't know that I couldn't make a recording. Fair enough. Then it can be interpreted that he has the author has donated his material to the public, and it would be very hard for that author then to contradict that interpretation.
Would it be valid then to make that known by putting just a copyright notice, for example, on the bottom of the slides?
Very good question, and that's the practice. That's absolutely the practice. So you're going to present your speech. You're going to make known in verbally or by a written copyright statement, which I have done. And I mean, I've done that just by way of example. I'm not too proprietary over the content of my slides, really not. But that is by way of an example. A little copyright, a little C with a circle, the year of authorship and the name of the author is a way, as a warning, that the person is claiming copyright in the content of the document. In the absence of that statement and in the absence of a verbal warning, the audience, the receiving party, will not know, and his defense, and he would succeed, is that it is free for public use.
Okay, thank you. I've got one further question, and then I think we can move on. The other questions probably will relate to what's still coming up, and that is, I think it's actually you just answered it, which is, as a speaker, you don't need to protect yourself more than, say, for example, putting a copyright notice on the bottom of your slides. Would that be enough? You don't need the audience to sign any agreement or anything like that.
Oh gosh, no. Oh gosh, no. That would complicate things, and the Copyright Act makes no provision for those unnecessary hurdles. A mere statement, you've got copyright, it accrues to you automatically. The copyright statement is not a requirement for copyright to vest in you, but it is important as a statement that you do not want other people to use your copyright.
Sorry, Roy, I've just realized that I missed Vilmeen's question, which is if person one gave a verbal agreement, so this is on point 3, if person one gave verbal agreement to point 2, is that enough?
That's enough.
There'd be permission.
No, there'd be permission and no infringement. Okay, everyone in the audience, I'm going to give my speech. I don't mind if you video it. My reservations, though, is please, when you video it, it's for personal use. Don't unsell it or don't donate it to someone else or to a broadcaster, but you're free to use it for your own use as a record of what I said. Perfect.
Okay, and verbal is enough for that.
And verbal is enough for that.
Excellent. We've got some really good other questions, but I think you can move on to your second example first.
Okay, example 2. And I've got Bruce to thank for this example. Again, it's a lecture room scenario, slightly different. So person number 1 develops a concept. It's a 4-point conflict resolution model. And instead of writing it down, he fixes this model in a keynote presentation, so PowerPoint keynote presentation. So it's now fixed in material form. And much like the first example, person number 1 has copyright in his conflict resolution model as presented in the presentation. And again, shares this presentation in a lecture room scenario, online, however, with the public. Person number 2 makes a copy of the presentation. And again, here it all depends on whether the copying was done with permission or not, and we'll assume it was not done with permission, okay, because that does change the scenario quite a bit. But here's a different question. Okay, so the first question again is the infringement, and much like in the first example, I think all of you would agree that in making a copy of the presentation without permission, we have copyright infringement. And will this conclusion change if person number 2 adapts the presentation? So he takes the presentation and makes quite a bit of changes to the presentation and then uses it. So he makes an adaptation. Will your conclusion change? And there I would say, bearing in mind that the exclusive right a copyright owner has is not only he has the the exclusive right to make a copy, he also has the exclusive right to adapt. The extent of adaptation is, there's no hard and fast rule. It has to be determined on a case-by-case basis, but making an adaptation, taking the work and adapting it while keeping the substance will not give the person number 2 a defense. In fact, he would still breach copyright and he would infringe even if he made an adaptation. And person 2 then uses this in a commercial manner by running workshops using the copied or adapted presentation. Will this change your conclusion in point 3? So I will answer that and say, look, it doesn't, your intention, how you use it, how you use your presentation does not change the factual analysis. Has that person, or has the copying of the presentation been a copyright infringement? I will still infringe copyright by just merely making a copy. Whether I then commercialize it doesn't make my copyright infringement worse. It doesn't make me fall foul of a greater level of copyright infringement. I'm still an infringer of copyright. The fact that I then commercialized it gives the copyright owner another remedy. So in the case of copyright infringement where I don't do anything and don't make any money, the copyright owner can stop me. Stop. And he goes to court to get an interdict. But if I haven't made any money, there's no damages. If I make money out of the copy, I can be sued not only for an interdict, stop using work of art, my work of literary merit, for which I have copyright in, but also pay me back my damages, the amount of money you have made on my work by commercializing my work without my permission. So it doesn't change the infringement issue. It just changes the number of remedies that the copyright owner has against the infringer. I'll stop there. I'm sure there'll be some questions.
Okay, so let me go back to our list here. So Theodore's got a question about quotations. Is using a quote without referring to the original author within a public speech a copyright infringement? What's the difference in a copyright infringement and plagiarism?
Yeah, well, at the end of the slideshow, I've got the difference. So we won't. Okay. I won't answer that plagiarism question just yet. But taking a quote out of another work and using it, it depends. Okay, does it fall into one of the exemptions? Is it fair use? Is it a fair use? Are you using it in a teaching context? Are you using it for your own personal use? Are you using it for research? And have you then adequately notified and referenced the original author? If you've done all of that, then you probably would fall into one of the exemptions. If you don't fall into one of the exemptions and you have authored a book with a huge chunk or a large amount of quotations, you could conceivably be fall foul of copyright. And there it is, well, the extent. And in copyright law, what really matters is not the amount you take, it's the substance. It's the quality that you take, not the quantity. But the smaller and smaller and smaller the amount that you take out of a copyright work, the less and less and less the copyright owner, the less chance the copyright owner is going to be able to prove copyright. Because if I, for example, copy paragraphs out of a book and put it into my book, clearly I've taken a substantive part of a copyright work and put it into my own. Copyright infringement would not be hard to be proved. But if I take a sentence, is that copyright infringement? Perhaps it is. It depends on whether that sentence carries with it originality, carries with it meaning and substance. If it is an ordinary, benign sentence with ordinary English words put together in a ordinary, to express an ordinary feeling or concept, then perhaps not, because copyright is not there to as a tool to monopolize the English language. It's there to monopolize, for the benefit of the author, creative merit, work of creative merit. So again, all I can say, case by case basis, and it really is substance and the quality that you take, not the quantity.
Lovely, thank you. Alison has asked a question, and Alison, I might need you to jump in and elaborate here. Is a reserving rights statement only required when it isn't obvious that something's been fixed? Or do you need reserving rights even if it should be obvious that it's something fixed?
Oh, I'm going to please ask that question again. I'm not quite getting it. So, reserving rights. So, okay.
Alison, maybe you can just jump in and ask your question using your microphone.
So, Roy, you made the statement after example 1 where you said that the speaker at the beginning of the presentation needed to say, I'm reserving my rights.
Yes.
Now, that was a speaker who we wouldn't know necessarily had written down their speech. Is that the reason why they had to say they're reserving the rights? If we had known it was a written speech, would they still have to say they're reserving their rights?
Oh, that's a very difficult question. If he's comes unprepared with a speech in his head and there's no written record, he has no copyright. He has nothing to claim until such time as it is recorded. And that recordal can be him arranging the recordal with a third person recording the lecture or not, or it can be a person in the audience. And I can't see how a lecturer, a speaker who hasn't recorded in any way his speech can claim copyright. I just can't see that scenario. And then if I can't really, it's a very difficult question to answer, because if it is then recorded by a person in the audience and that person doesn't know that the speaker is reserving his rights, well, he can't reserve his rights because he has no rights to reserve.
Sorry, Roy, can I just jump in? I'm saying, so I've written down a speach.
Yes. Okay, so you have copyright in that speech.
Yeah,
yes.
So I've written it, so it's got copyright. But
yes.
I didn't bring that piece of paper to the lectern, and I spoke.
Yes.
And you have remembered my words, and you now want to use my words. You made the mention earlier that the speaker has to have said, I reserve my rights.
No.
Okay.
No. I think you don't conflate with the accruing of a copyright in a work of literary merit and whether or not another person can use it, because that first, the speaker has copyright. It's now whether in speaking, whether he's giving permission tacitly or expressly for the audience to use it in a unlimited or limited way or not. So by him not saying up front, I am reserving my rights to the content of my speech, he's giving the tacit impression to his audience that his audience can use the content in any way that they see fit. And in that scenario, and if the speaker was then to assert his rights against the so-called infringer, the infringer has a very good defense that there was no limit at the time of the giving of the speech as to how I could or could not use it. I hope that answers the question.
Yeah, that's spot on. That last part is exactly it. Thank you very much.
Yeah, he's still got copyright. He still has it. He hasn't given it away, but he's just said, I've got it, but without saying anything, because I haven't said anything, you're using it. Well, it's my bad luck because I wasn't clear, and you've got a very good defense.
Very good. Roy, I've got a couple more questions here, but maybe the one that's most relevant right now, and I'll come back to the other ones, is from Lois saying, asking the question about, if you videotape your speech live, would that protect you?
Okay, so really it's not really protection is the wrong word, because you've got, if you don't record or reduce to material form or fix whatever you are thinking, conceiving, conceptualizing, you have nothing to protect. You only get something once you take whatever's in your head, and that's why it's called intellectual property. Whatever's in your head, your intellectual capacity, your little neurons firing, your little thoughts, those are not intellectual property rights. They can never ever be considered intellectual property. Something has to happen to your thoughts. Your thoughts have to be organized. They have to be organized creatively. And they have to be organized creatively in a embodiment, in a fixation, in a material form. Once that happens, you have copyright. Once you've got copyright, it's an asset. An asset you can then sell, license, keep. And if you keep, you can assert. You can say, no one else can do what they want with this work of art, this work of literary merit, this work of music. I am the one in control, and I dictate whether I want it reproduced, whether I want it broadcast, transmitted, adapted. I'm in control of that process because I'm protecting an asset and I'm protecting a revenue stream.
Very good, Roy. Roy, I've got a few more questions here, but I wonder if we shouldn't, if you want to move ahead with your finishing.
Yeah, sure. So I've just got
then...
yeah, okay. I've just got one more example, and this is a fun example. So it's not a lecture room. This is a waterfront scenario. So a bit of fun here. Zoom out as opposed to Zoom itself, but zoom out as in just to illustrate that different people, as they involve themselves in a scenario, can create different works which give rise to copyright. And that even if you originate copyright in a different scenario, it's not necessarily a defense for infringement. You can still infringe, but have your own right in copyright. And this is kind of like a scenario where that happens, where you're zooming from a small insular setting, a personal setting between person number one, sitting in the waterfront in Cape Town, drawing. A customer comes and the artist draws the customer's likeness. And the question I have there is, who is the owner of the copyright in the drawing? And I'll answer. Let me answer the questions at the end. So we've got that context. So there definitely is a drawing, and that is a work of art, and that accrues copyright. Then you have a tourist that passes by, and he takes a photograph of this beautiful waterfront setting with the buildings and the boats, and included in that photograph, he includes person one and person two, and very clearly there is the picture of customer or person, customer number two. There is his likeness photographed or included in that photograph. And zooming out still further, there is a second tourist. He is taking video footage of the waterfront. So you can understand here that he's passing by and he takes this video footage of the waterfront, which includes the tourist taking the photograph of the customer's likeness. That video, the second tourist then takes back to his home country, gives it to a friend to watch. The friend edits the video and uploads it to YouTube for the purposes of marketing Cape Town. He's got an interest in marketing Cape Town and all that it has to offer. Well, we have got a number of potential works of independent copyright merit and or infringement. So let's zoom right back into the original insular two-part play out between the artist and the customer. And the artist is the author of the drawing, but the customer has commissioned the artist to draw his likeness. So in this particular context, and it's one of those exceptions to the rule that the author is the owner. In this case, the author is not the owner. The person who commissioned the author, being the artist, is the owner of the drawing. So he takes away not only the physical drawing itself, but copyright in the drawing. In other words, he takes home with him to hang on to his wall, his likeness, and the ability to adapt, reproduce, broadcast, etc., or adapt copyright in that drawing. Is the tourist who takes the photograph, is there a work that accrues a copyright, independent copyright? And the answer there is probably yes, because the author, the tourist, very carefully and creatively got a particular setting. He didn't just take a photograph of the drawing. He got context, and he got the waterfront, and said, this is just a lovely view of the waterfront as a whole, with this artist sitting in the corner there drawing this picture. And I would say that he has copyright in his photograph. It is a work of art, a work of artistic merit, independent of the copyright in the likeness. And so there is copyright there, but does he infringe the copyright of customer 2, of person number 2, the likeness of which was drawn? And there I'd probably argue that this is fair use. It's a fair use exemption, that the photograph is for personal and private use. So he is not infringing the copyright in the drawing A. The second tourist taking the video footage, again, I would say there is independent copyright in that, because again, there is originality. And the one still showing the tourist 3 with the person 1 and 2 in it is one of many frames in a video showing all aspects of Cape Town and the waterfront. And most certainly he would claim and can rightfully claim copyright in the video C. But does he then, that's no defense to infringement. Is there infringement in the copyright of A or B? And again, there I would say certainly in A, there is a fair use exemption again. And in copyright in B, well, it wasn't, the B is the taking of the photograph, which wasn't actually part of the video. So there is no copyright infringement of A or B. And then lastly, we're looking at the video that is then given to the friend who uploads it. And here I would say, is the friend 5 in uploading and broadcasting in a way, in giving or disseminating to the public, falling foul of copyright in any of those copyright works? And I would say yes, most certainly. Even though he may have adapted it by editing, adaptation is not will not avoid infringement and work as long as he's taken the substance. In the video that his friend gave him, so his friend who had copyright in the video can certainly sue his friend number 5 for uploading to YouTube his video. And there is no fair use exemption because it's not for personal use. It was certainly for commercial use. Even if he wasn't going to be remunerated directly, there was commercial motive. So the fair use exemption would certainly not apply. And I would also say that he has no copyright in the edited video, merely because there's no originality in editing. It was merely taking the substance of the video, taking parts out and repackaging it as an adaptation of the copyright in video C. So he doesn't have independent copyright, and he probably would infringe copyright in video C.
Very good. Thank you, Roy. Roy, do you have more to offer?
Okay, so
or should we go to the final Q&As?
No, that's fine. So lastly, and that was that question about plagiarism. So copyright infringement or copyright and plagiarism are not the same thing. They do sometimes overlap. But plagiarism is an ethical violation of an academic norm. It's a violation of a norm. It's not a violation of a law. It typically, the norm is conceived in academia, and an academic who is guilty of plagiarism will be shunned, excluded, and there may be something codified within his employment contract which would result in him being fired, dismissed from his employment as an academic within a particular university. But that doesn't necessarily make it illegal. It is a violation of a norm. Copyright infringement is illegal. It's a violation of a legal norm or a legal standard as opposed to an ethical norm or standard. Plagiarism is an offense to the author. So it always goes back to the author, no matter how many times the work has changed hands in terms of ownership of that copyright. You are only cheating and cheating the author. Copyright infringement is an offense against the owner. So the work of the copyright work can be transferred multiple times, and it's only the owner that's going to be damaged by the copyright infringement. Plagiarism applies to ideas. So you can plagiarize a person's ideas in a verbal setting where two academics are in the park and they're talking. One is talking about his eureka moment, which he has not had the time to fix, to write down, to claim copyright in anything. He's just got these fantastical ideas, which he then gives to his colleague and to sound out. The colleague runs away and incorporates that in his own work. That's plagiarism. It's not copyright. It's not copyright infringement. And lastly, plagiarism is there to apportion academic credit to the academic who conceived of the idea that has been plagiarized, as opposed to the production of the protection of an asset, being the copyright, and potential revenue streams that flow from that asset. And that is that.
Thank you, Roy. Are you okay if people do contact you with any follow-up questions? I guess you can always decide at which point it needs to become billable.
I have no problem. I'm not even hesitating about that. Copyright's a funny thing. I typically with anyone phoning me and contacting me, I freely give away an hour of my time.
Wow, that's extremely generous. Thank you very much, Roy. We really appreciate that. Roy, should we move on to take any further questions? I think we leave your slide up for a moment in case people do want to take down some contact details. Is that okay?
Fantastic.
Okay, so let me go back. I think there's a couple of questions and they seem to all sort of join together. I think very, very practically, for those of us who are speakers, what should we actually do that would protect our rights without, you know, obviously anybody attending a speech, we're very happy for them to implement that for personal use. But is there anything else we need to do other than maybe, I see, for example, you've got a little copyright statement at the bottom corner of the slide.
Yes.
Is that enough? Do we need to do anything else? There are a few questions around that.
Yeah. No, I look, that's enough. No. Yes and no. That is enough to make a statement that the person giving the presentation, the speech, is claiming ownership of the subject matter in the slide presentation or whatever. It doesn't really take it further. It should then put the audience on guard, and it would be a lot harder for the audience then to take that away and use indiscriminately, because that should elicit, and the onus would be on the audience then to ask the question, well, to what extent then is the author reserving his rights? But to preempt all of that and the shifting of the burden or an onus of proof, make it clear from the beginning. This is a work that I'm claiming copyright in. You are free to use it in your personal context. In other words, you can recite verbatim the fair use exemptions. And that is it. You cannot use, adapt, broadcast, transmit, translate into another language the content that I'm giving you for remunerative benefit. That is where it stops, and that is an abuse, and certainly wouldn't fall into any fair use exemption.
Okay, thank you. I think for a lot of us, you know, the thought of standing up in the early part of our keynote and sort of starting to make statements about what you can and can't do with it does feel a little foreign.
It does, and but it's probably necessary if you are going to, if what you are giving is of value, and it typically will be of value. It's not something that you're going to freely give away. This is your bread and butter. This is something that you generate and disseminate on condition that it's used within certain predefined parameters. And I think those parameters have to be put across either in the way of emails before the audience arrives. So in the application process, or when they sign up, or after the presentation on the last slide, or just a reference to your terms and conditions, and that's another thing, to terms and conditions that may be found on your website. So you don't have to, set out in uncomfortable detail in the presentation. There are ways of getting across to the audience that they have no ability to argue that they weren't or should not have been or reasonably could not have been aware of the conditionality attached to your presentation.
Very good, thank you. I've got a lovely question from Marelise. If we want to use somebody else's ideas as part of our presentation to strengthen a point, is giving credit to that person enough? How do we do that legally?
Ideas. Again, and you can use someone's idea as long as you don't, that's plagiarism, if anything, as opposed to using an extract. So, and because an idea is not the subject of copyright, an idea really, at best, if it has academic merit, you could be accused of plagiarism, but if you're not an academic, well, what sanction? So use ideas. Ideas are free. And I'm quite strong on that. Ideas are a dime a dozen, everyone's got one, and they are free. Copyright is not. If that idea is codified, if it's fixed, if it's and you take an extract, then yes, you would need to ask permission if it's not fair use, if it doesn't fall within the fair use exemptions. So using that in a professional speaking environment is not a fair use exemption. It's not even a teaching exemption, because a teaching exemption, you could argue that's teaching. A teaching exemption is a very, very detailed exemption, and I don't really want to recite it, but it's not, it's more teaching in a classroom setting, and your intention is very, very important. So I would argue that that's not teaching. It doesn't fall into one of the exemption. If you don't have permission, you would fall foul of copyright, even if you gave them credit.
And that would be even if you quoted, say, one sentence from their book.
That's a difficult one because, again, it comes down to substance and quality, not quantity. Was that a qualitative sentence or not? I don't know. That would really have to be on a case-by-case basis. But then I think practically, let's just boil it down to a practical level. Okay, so I take a quote out of someone's book and that quote has a qualitative merit. There is, what is the owner, the copyright owner, going to actually practically do? They can write me a nasty letter. They can get their attorneys to write me a nasty letter saying, stop. Okay, then I'll stop. If I haven't made any money out of it, there's no damages. So practically, the copyright owner is certainly not going to go through the process of launching a court action against you, which would run into 50 to 100,000 rand to get an interdict to stop you, when all he could have just done is just say, please don't do that. I'm claiming copyright in that sentence, so stop it. Okay, I'll stop it.
Excellent, thank you, Roy. I know that Carl has a question he'd like to ask, but it would be better if he opens his microphone. So Carl, over to you.
Thank you, Ian. Hi, Roy. Thank you so much for your advice. Just a question. If, let's say, like your presentation that we're now recording, yes. I can see it's being recorded here. Let's say we took this content, or what would we have to do to take this content and put it onto our membership site as a benefit to our members? In other words, our members pay a membership fee to belong to the association, and included in their membership fee is a whole lot of videos and presentations, of which one of them is yours.
Yes.
What would we need to do in order to use your material like that? Would I have to get special permission from you, get you to sign a document or something like that?
Cole, it doesn't have to be formal, but if we go back to first principles, there is copyright. Use without a license, without permission, is copyright infringement. Practically, there's very little that I would do because it simply doesn't justify the cost. But that's what those are the kind of steps you'd go through to kind of analyze. However, if you want to use it, or you want to use anyone's content, it's merely just asking the author, the owner, do I have permission? May I have your license? Same thing, to do X, Y, and Z. Oh, absolutely, of course. Should that be written down? Well, that's an agreement. Okay, so you're discussing with the person who wants to publish it, use it, and outcome of that discussion is an agreement. No, you can, and these are the conditions. No, I won't expect you to pay a royalty as long as you just keep my name there, and I can benefit from the referrals, etc., etc. That's an agreement. The problem with verbal agreements is evidentiary. You know, it's the terms will be disputed because, you know, imperfect memory. So it's always advisable then to reduce it to writing, and typically writing can be an email exchange. But that's practically what you know you should do with people's content if you want to do something like that.
Thank you. Yeah, that answered my question, because I have members and they pay a membership fee, and I interview experts and put those recordings up for my members to watch, and they obviously pay a membership fee, and included in that is all the content. So I'll just make sure I get just a written permission, just a short 2-3 sentence.
Yeah, absolutely. You don't have to get too legalistic, really don't. And I mean, you know, going back to the Consumer Protection Act, which is not, you know, relevant here, but one thing the Consumer Protection Act has introduced to South African law is plain English. Just write it as you say it, and get that email exchange, and just keep those emails. And
perfect. Thank you. And then just another follow-on question from that, public content on YouTube. If Ian, for instance, had to put his keynote presentation up on YouTube, open for public view, and we watch his keynote there and use some of the content out of his keynote, would we be infringing on any copyright?
That's a difficult question, because I simply don't know the terms and conditions on which, and that very much depends on the platform YouTube, and the terms and conditions when you're uploading. So in the absence of terms and conditions, again, first principle, there would be copyright infringement if the content is uploaded to YouTube, and then you take from YouTube extracts of that presentation. Yes, that would be copyright infringement. Perhaps in using the platform, the author, the uploader, has given permission for the use in a certain by certain means or methods, and that I don't know. But just on first principle, yes, it would be copyright infringement.
Thank you. Thank you very much.
Roy, thank you, Roy. I'm going to just pose one last question. I've just gone to look through all the questions, and I apologize for any that I've missed. We just got too many. But there's one idea that I think is maybe quite important just to give us a little bit of advice on, and that is, should we discover that somebody has been replicating or duplicating something that we either teach in a classroom or as part of our keynote or something like that, what advice do you give us as how we should handle that?
Yes. Nip it in the bud as quickly as possible. You don't want to get into this scenario where you leave the practice to carry on, and then the person, the alleged infringer, then says, well, you've waived your rights. By your inaction for 6 months to a year or whatever, you've waived your rights. If you wanted to claim, if you wanted to assert your copyright, you should have done so from the onset. You've let me carry on for 6 months, and that implicit in that is a license, is a tacit license to do what I'm doing. So you don't want to get into that kind of waiver scenario. That's the first thing. So just going back to the question, could you just read? So I've lost the original question. So that's just one thing to.
So the question is, what should we do if we discover that somebody else is infringing our copyright?
Yeah. So act quickly, and and the only thing you can really do in action is you, or through an attorney, you write a letter, and you make it very clear that you're claiming that you have and are claiming copyright in a particular content that the person's using. You make the allegation that the person's using it, the allegation that that person's using without permission, the allegation that the way he's using it, there are no fair use exemptions. The conclusion being that there's copyright infringement, and to stop. And failing which, you have no other choice but to approach the courts for remedy. Very rarely would you ever do that, simply because of the cost. But the letter should be enough. If it isn't enough, you can draft or get your attorney to draft summons and issue summons. The drafting of summons is not the expensive part in litigation, it's the courtroom battle. And I can tell you right now that that summons would stop them.
Excellent advice. Thank you very, very much, Roy. Roy, I think we're going to wrap up now, so you can stop sharing your slides. That would be good. We can get everybody's video up to full size again so we can see each other for the wrap up. And I'm going to hand back to Bruce, but Bruce, I'm going to ask you if you wouldn't mind in your wrap up just to hand back to me. I've got one little announcement I'd like to make at the end.
Okay, perfect. Thank you very much. Wow. Okay, my head is spinning. I'm just thinking of how guilty I have been over all the years. So to everybody here and every other person that ever wrote anything down, I am humbly sorry for copying and plagiarizing and using. But yeah, it's an eye opener, and I think that is something that we kind of spoke about in the beginning, is that now that we've moved out of that unconscious ignorance into conscious ignorance, now that you know that you don't know something and maybe we know a little bit about that, we can start doing something about it. And that's an interesting thing. So just looking at little inclusions and those things. So yeah, very, very interesting. Roy, thank you so much. Once again, you've helped us out a huge amount of stuff of curing our ignorance. So that's the second speech I've heard from you in a month, and I'm feeling seriously guilty about a whole bunch of things. So thank you for that.